Hello, my name is Dave Zapponi. I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. Thank you for participating in this community conversation, government policies affecting HOA home values. ECHO is a statewide nonprofit association established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. These are now presented on the screen. In addition, slides were sent to registered attendees beforehand. Please take a moment to review our housekeeping items on those slides. We have many HOA board members in attendance today, which usually means a lot of questions. We will do our best to answer them. Please use the Q&A icon, not the chat icon, to answer your questions and make comments. You should use the chat icon to report technical issues and to communicate directly with other participants in the webinar. You will find these navigation icons by hovering over the bar at the bottom of the page. I will respond in writing to some questions in the Q&A feature during the presentation. All other questions will be answered during the Q&A session after the presentations. Please keep your questions general in nature. Questions about specific situations are best asked one-on-one. To help us select the most relevant questions for this audience, please use the thumbs up icon found on the Q&A screen at the bottom left corner. Simply click the upvote icon to select your favorite questions. And now for our disclaimer, which you'll find on the screen. None of what is said during the seminar shall be construed as specific legal advice or expert advice from the speakers, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. Thank you. Today, we have several sponsors. Please join me in thanking our premier sponsor, the Kevin Boland Insurance Agency, and the program sponsor, Silver Creek Association Management. The Q&A session sponsors are CID Consortium, LLC, Hughes Gill Cochran Tinetti, PC, and Monster Tree Service. The registration sponsor is Levy Erlinger and Company, CPAs. Now we will have a few words from our program sponsor. Connor, please roll the video.
Hi, I'm Laura Rabaza with Silver Creek Association Management. Our core mission at Silver Creek and the touchstone of everything we do is to manage communities with its people in mind. That means we don't just aim to check off standard management boxes, but to listen and cater to the unique individual needs of each and every member of a community. We believe in enhancing the livelihood of communities through our unparalleled dedication to customer service, our ability to offer professional expertise in all areas of HOA management, and our tireless drive to ensure that the communities we take care of are heard, happy, safe, and thriving. We aim to consistently go above and beyond the confines of typical HOA management duties. It's because we genuinely care about how your community functions. We understand that managing a community can be a demanding responsibility, but our team of experts understands how to get things done with efficiency and finesse. Please let us know how we can help you and your community. I hope you have a great education workshop today.
Thank you to Laura Ravassa and Silver Creek Association Management. And now I'd like to introduce the Kevin Boland Insurance Agency. Kevin would like to say a few words about his insurance agency. Kevin?
Hi, everyone. My name is Kevin Boland, and I'm a farmer's agent based in Novato, California. I am very excited to be, again this year, a premier sponsor for ECHO. You know, I also serve on my board, and I can't tell you how many times I've learned so many things. I now know how to manage roofers, painters, electricians, plumbers, asphalt professionals, even lawyers and attorneys, and even lawyers and CPAs. My wife even says I'm a better husband because of my membership in ECHO. So I have a spoiler alert. I have a brand new educational video that's going to be coming out really soon, and it's on the topic of interior water claims. I discovered that over the last year, A lot of homeowners and board members and even some association managers don't understand how to manage a water claim and which insurance company is going to pay for what. So I think it's going to be a useful video, and look for that in your email inbox soon. And of course, if anyone has any questions, you can always reach me at kevinbolandinsurance.com. And if you would like a professional bid on your association's insurance, I continue to get fantastic rates and even some brand new coverages with Farmers Insurance.
Thank you, Kevin. We really appreciate your sponsorship and your continued sponsorship. Kevin will be speaking at the Ask the Experts about insurance later on this year, I think in June. We will also be giving away 2 $50 Amazon gift cards, courtesy of our gift card sponsors, Divergent Consulting and Silver Creek Association Management. You must stay to the end to be eligible to win. Thank you to all our sponsors. They make this event affordable to anyone. Our community conversation today will feature presentations on 2 topics. First, we'll hear from Krista Pleiser and Marta Brown of Smart Coast, California. They will discuss California coastal policy and working with the California Coastal Commission. Following Krista and Marta, attorneys John Gill and Zur Iyer of Hughes Gill Cochran Tinetti will discuss new Fannie Mae and Freddie Mac guidelines and the implications to HOAs and to homeowners in HOAs. Krista and Marty will begin the program, followed immediately by John Gill and Zur Iyer, and then the Q&A session. Remember, you may ask questions during the presentations in the Q&A feature. Krista and Marta, please begin.
Good afternoon. I am Marta Golding Brown. I am the Government Affairs Director for the Ventura County Coastal Association of Realtors, and I'm co-creator with Krista of Smart Coast, California. We are next slide. We are an organization that is a 501c6, and we are here to promote and advocate for property rights and smart land use policies affecting our coastline. We vet policies and we consider each community as unique and not one size fits all. That's really important to us. And we have a multi-pronged approach to common sense land use when it comes to coastal areas. Next slide. Our board this is our board. It's made up of realtors at this time. It will be transitioning into non-realtor board members starting with 2023. Next slide. You can see that our board members are up and down the coast. We did have one that rolled off this year, and he was from Humboldt. So we do clearly consider ourselves a statewide organization. The gentleman from Humboldt has remained active with Smart Coast California, and we are watching what's happening with local coastal programs and sea level rise plans that are going into effect or going in for consideration with the California Coastal Commission from San Diego to Del Norte up north. Krista.
Hi, everyone. My name is Krista Pleiser. As Marta said, I am co-creator with Marta on Smart Coast, California. I too am also a government affairs director for the Santa Barbara Association of Realtors. And we wanted to inform you about a little bit about the Coastal Commission and give you some information regarding them. So a lot of you probably already know how the Coastal Commission was created, how it came to be, but a lot of people don't understand their key statutory responsibilities. And part of that is coastal management programs, specifically local coastal programs. And what's very interesting about these programs is that this is basically the general plan, but within the coastal zone. So what's really important about this, and the main thing that we want to be able to emphasize here, is that per the Coastal Act, there actually is a partnership between state and local governments when they are dealing with these local coastal programs. So we put just a little bit of a timeline on here for you in the standpoints that these LCPs are prepared by local governments. They get input by Coastal Commission staff. They're adopted at the local government level. They're then submitted to the Coastal Commission. And then once the Coastal Commission decides what they're going to do, then it gets sent back to the local government for final approval. Now, what's really interesting about this is that a lot of local governments didn't know that they have the option to be able to tell the Coastal Commission no at any point within this process. What else is super important about this process is that people in the community, and this is where HOAs really can jump in, is having input at all of these steps. Because once it gets to the Coastal Commission, it's kind of a done deal at that point. So being able to get involved at the local level in the very beginning is huge. Next slide, please. We've actually had some results in the standpoints of being able to tell these jurisdictions down in San Clemente, Del Mar, and in Santa Barbara County, hey, by the way, you know, you don't have to adopt what the Coastal Commission is telling you that you have to adopt. So based upon that, these 3 jurisdictions just last year withdrew their LCPs, and LCPA means Local Coastal Program Amendments. So that's when they're updating them. Basically, what this means is that these jurisdictions said, no, we do not agree with you, Coastal Commission, on, for example, having an existing development date of 1977, or trying to push through managed retreat, or any number of interesting modifications that the Coastal Commission tries to put. So we will continue on with our Smart Coast policies and then kind of circle back to this. Marta?
So Smart Coast California has adopted 5 policies: managed retreat, existing development, regulatory takings and rolling easements, and tiered responses. Next. So with managed retreat, this seems to be a one-size-fits-all go-to for the California Coastal Commission. And the practice of managed retreat is physically moving the dwelling unit to another location away from the water and away from the tidal inundations. And they seem to think that this can be accommodated with all structures up and down the coast. And it is our Smart Coast California, it is our policy that managed retreat actually should be more of the last step, not the first step in what you do with properties that are along the coastline. Next. The next one is existing developments. As Krista said, the California Coastal Commission was created and through,
Initiatives.
Totally lost it. Initiative in 1976, and it was started in January 1st, 1977. So the California Coastal Commission is trying to say that they will only consider dwellings that you can protect them if they were constructed prior to January 1st, 1977, which is, we believe, is wrong. This date is not constituted by law nor regulation, and it would restrict property owners from defending their properties, even if those properties were built within the proper permitting process through their local governments and a California local coastal plan. So we oppose the use of January 1st, 1977 as an existing development date. Next. Regulatory takings. Anybody who is not allowed to defend their properties, this would be constituted as a regulatory taking. And so we have been advising local governments that they don't have to, as Krista said, and typically it's the staff comments that come back prior to the Coastal Commission hearing to the local governments that say, we need you to do managed retreat and we need to accept the 1977 date. And what we try to tell the local governments is, if you accept that into your local coastal plan, then that would be considered a regulatory taking of that property if they're not allowed to defend their legally constructed dwelling unit. Next. Krista?
Yes, thank you. So rolling easements, this is kind of like managed retreat, but it's a little bit different in the standpoints of the median high tide, or even an arbitrary number, moves every increment, at an increment of either with sea level rise or with timelines. And so as you can kind of see from this pictorial, you can see that today you can have the private public land and the high water line be, quite a bit away from the dwelling. And over years, that line continually creeps up, at which point then the line just takes over the property. The major question that we have here is the fact that if you have this, when does this constitute a takings? Is it when it's in your backyard? Is it when it's part of half of your building? Or is it the whole thing? Once we have been able to put once we've been able to put these questions forward to the local governments, a lot of them have withdrawn this from their plans because they realize, oh, this is way too much of a quagmire for us to be able to enter. Next. Tiered response. So the logic behind this is that it's more prudent to wait and see if the projected sea level rise would manifest within the timeframes postulated, even if at all, and we say it all because we believe sea level rise is happening. It is occurring. We know it's happening. However, there are different places in California where, depending upon the tectonic plates, it's actually pushing the land up some, and sea level rise is actually dropping from those areas. So it is a very unique, area by area that we need to look at. And so based upon this, we want to make sure that, hey, if say you say it's going to raise by 3 feet, then once it does raise by 3 feet, then we can sit there and go to the next response, whatever that may be. Maybe it's protections, which we can get into right now. Next slide, please. So there's various protection options. And what's very interesting about these protection options is that a lot of these, although they are done on the public side, we're starting to see more and more on the private public side, which is very exciting. And we'll be talking about that in a minute, but we have different protection options all the way from dune restoration, all the way to hard, which would be seawalls. We're really excited about artificial reefs, and we're going to show you an example of why this is pretty exciting and why this is something that's actually being picked up by quite a few local jurisdictions as a possibility. Next slide. Beach nourishment. I'm sure most of you have probably seen where along a beach somewhere they go and they start dredging a harbor, or they start dredging a beach somewhere that has too much sand, and they go and they take it to another location in order to fill up that beach. While this is a soft solution, one of the issues with beach nourishment is that it can get taken away in one storm, and all of that work and money are just gone. But it does help if you couple it with other of these options. Next slide, please. So what's really great about this is an example of artificial reefs. So this was done in the coast of Australia. As you can see on the left, there was storm erosion on this beach back in '96. This picture was taken at high tide. They then put in these sand reef constructions. And by 2001, you can see on the right that also taken at high tide, you can see the beach is wider. You can see that the parking lot is protected. You can see more of that grassland, and it's a healthy beach. What else is also interesting about this is that surfers actually really like this as well, because they found that the surf is much better. Next slide, please. So then we also get into seawalls and hard protection. The interesting thing about these is that while the Coastal Commission is a very hard no on these, more and more locals are starting to see this as, okay, as the very last option, we can look at seawalls. This is once everything else has been looked at and everything else has just been thrown out the window because it just won't work. What's interesting about this, next slide, is that they can be put into these things called geological hazard abatement districts. Now, these have actually been around for a number of years, but they're really starting to gain popularity now, like I said, with the locals. This is a private-public partnership, and this is where the cities or the local municipality shares costs with the affected property owners. So what's really interesting about this is that we are seeing more and more, including HOAs being part of this, of going into these GHADs, geological hazard abatement districts, and being able to protect their portion of the coastline. And it's not just their tiny little portion, it's even more in order to make sure that it's all being safe and that it's not getting destroyed. So this benefits a lot of different people. This is, obviously the private property. It helps protect the tax base. It gives more beach access, and it gives more recreational value. As an example, along the Pismo Beach coastline, there is an idea of constructing 4.5 miles of an artificial reef to protect the beaches in development. And it's going to go along the Pismo Beach coastline. And they are saying that the cost would be $47 million, which that would be a little over $10 million per mile, which sounds like a lot of money. But when you take a look at all the different homes, it's that picture on the top. If you look at all of the development that's up there, it's actually, I'm going to say, chump change, so to speak, compared to how much a regulatory taking would take at the cost of those homes. So it's a win-win for everybody. Next slide, please. We're actually going to be talking more about this information at our policy summit, which is going to be on May 20th in Long Beach. We know that you received this information in your packet. We are giving ECHO members the early bird pricing still. So please come on over and grab. And next slide, please. You can connect with us by using these QR codes or just going to smartcoastca.org. Thank you.
Thank you very much. John, I think you and Zur are next. So Zur, I think you're going to talk.
You're up. Good afternoon, everyone. Thank you for having us. Thank you to ECHO for putting on today's presentation. Today, my partner and I, John Gill, will be discussing new Fannie Mae and Freddie Mac guidelines. Next slide, please. Before we jump into a rather technical topic, we thought it'd be important to discuss and just briefly provide an overview of the basics here. So what is Fannie Mae and Freddie Mac? These are federally backed lenders that provide loans for real estate transactions in the United States. And in the course of making determinations about whether or not these lenders grant loans, they go through the process of essentially assessing the risk associated with a loan. Typically what happens is that the lenders will submit questionnaires to associations to help the lender evaluate the financial stability of the association and the lender's risks involved in lending on a property like this. The questions that used to be included in the standard Fannie Mae and Freddie Mac questionnaires were objective in nature, so responses were generally easy to provide. They would ask how many units are in a homeowners association, what are the current assessments of the homeowners association, is there a rental restriction or is there not a rental restriction? So the nature of the questionnaires that Fannie and Freddie used to send to condominium associations around the country were relatively easy to answer, and they were typically handled as a result by the management company's escrow departments. Next slide. I'm sorry, next slide. So why were the questionnaires changed? So at the end of last year, in December, both lenders made the determination to basically add on, create an addendum that is attached to the standard questionnaire. And a lot of people have asked, well, why was this addendum necessary? What kind of was behind this? Well, in looking at the timing of this, and frankly, much of the information that's out there, we know that the addendums that have now been provided and are required are in response to the Champlain Tower South collapse that took place in Surfside, Florida. Most of you will be aware that, of course, last summer, there was a catastrophic failure of a single condominium complex building in Florida, which resulted in not just the tragic loss of life, but obviously essentially the destruction of the vast majority of that building. Although it's unknown how many of those condominium units had funding or lending through Fannie or Freddie, it's understood that that issue brought forward concerns for these particular lenders regarding structural issues at these condominium developments. Next slide, please.
Okay, this is me. So before we get into the new questionnaire addendum, again, just to understand what's happening here, Fannie Mae and Freddie Mac are publicly traded corporations that have basically a government charter and government protection to provide liquidity to the mortgage market. So there are a number of lenders that lend to condominium buyers or new home buyers, either with insurance protection from Fannie Mae or Freddie Mac, or able to resell their loans to Fannie Mae and Freddie Mac to provide the lenders with liquidity to keep making loans. So why does this matter? Well, Fannie Mae and Freddie Mac doesn't want to get stuck with they don't want to get stuck with a number of loans if there are safety conditions in the buildings, and the Florida catastrophe basically brought that to light. So any lender that wants to lend knowing that they can get funding, financing, or protection from Fannie Mae or Freddie Mac now has to get information to qualify for that program. So that brings us to this questionnaire addendum. Fannie Mae and Freddie Mac have always had a fairly formulaic questionnaire that they ask lenders to use to get information, but now they have a new addendum with new questions added that apply to condominiums and co-op buildings. But we may have some people that own co-ops in the audience here, but typically we're applying to condominium buildings with 5 or more attached units. The new questionnaire addendum asks detailed questions regarding physical condition of the buildings. Well, that's gotten the hackles up of many of the lawyers around the state and spooked board members and managers, because generally under California law, and there's a case, the Kovich case that I believe is on one of Zer's slides in a few minutes, that basically says homeowners associations do not have a duty to disclose construction defect claims or the existence of defects to third parties. Typically it's referring to buyers, but it's third parties generally. The lenders now are asking for this information because they want to work in the Fannie Mae Freddie Mac program. So boards and management companies are being put in an awkward position of, do we respond to questions related to the physical condition of buildings to third parties when we don't have a legal obligation to do so? And that brings us to the next bullet. They're requesting copies of board minutes and inspection reports regarding the physical conditions of buildings and decisions on an action plan that flow from it. The inspection reports, just as we talked about general disclosures, inspection reports are written for the benefit of board members to be able to make informed decisions. So when somebody writes an inspection report, if you get an expert, a contractor, an inspector, they're writing a report for the board to be able to make decisions about what the association should or shouldn't do in response. But if these are now being given to third parties, you have issues with association liability. You may have issues with the inspector that wrote the report not wanting third parties to rely on it. So if we go to the next slide, we have some significant concerns about the addendum questions. They're poorly, and these apply generally. Zer and I are going to go through several of the questions to give examples. Poorly written and hard to understand. How do you answer yes or no to a question if you don't understand what the question means or what they're specifically asking for? They use loaded terms that aren't defined. We'll give you some examples of those. Again, how do you answer a question if you don't understand the terms they're using? The questions don't specify a time frame. If you have a 35-year-old development and it asks, has the association ever X or Y, is there anybody that even knows the answer from the last 25 to 30 years? They request very specific information regarding safety and habitability of buildings. Well, there are a lot of value judgments attached to objective information that would affect whether it impacts the safety and habitability of buildings. And we're asking lay people that aren't qualified to make those decisions to provide subjective responses. And we refer to management companies and board members. Lay people typically aren't in a position to make such assessments when lenders can make those assessments themselves. The responses could have a significant impact on a lender's decision to lend. Obviously, we want a liquid mortgage market to enhance property values and allow people to buy and sell. But now those decisions to lend are going to hinge on decisions boards make about what type of information should be provided in response to an addendum for the benefit of a public company trying to make more money. And it injects associations into third-party disclosures that associations have never had to wade into. And so it brings us to the types of questions we're getting. And Zur, I think that takes us to you.
Yeah, next slide. So we're going to go through just a couple examples of the addendum questions that are now being provided. So there's a total of about 12. We're going to go through about 6 or 7 of them, just to give you an idea of really what these questions are and kind of justify what the concerns were that John just mentioned. So question number 1, in simple terms, is when was the last building inspection by a licensed architect, licensed engineer, or any other building inspector? So that is the question. Here are our questions in response to that question. Last building inspection or any other building inspector. Does this mean any sort of inspection of any portion of the building at any point? What if there was a termite inspection that was relating to the building in the course of a unit sale or a sale of a condominium? Is the association then obligated to disclose that termite inspection that it knew took place during the course of a sale in responding to these addendums, right? Are these inspections that only inspections that the association has retained or requested, or can this be inspections that individual owners do during the course of sales or remodels, whatever it may be of their units, right? So one of the primary issues with this is that these are really broad terms that aren't defined as mentioned before. And not to mention, there's no reference as to time. Are we talking about over the course, what was the last building inspection in the last year? Is this the last building inspection since the preparer was aware of it? Are we talking about the last building inspection since certain things took place? So again, very vague, very broad, and very, very difficult to answer. Next slide.
And what's a building inspection? Is it any part of the building, or is it a thorough full building inspection that maybe hasn't even happened? Anyway, question 2. There are a couple slides on the second question. Did the last inspection have any findings related to the safety, soundness, structural integrity, or habitability of the project's buildings? I'd make a joke and say this seems so simple, but it's not a joking matter. So how is soundness defined? Zur and I went to law school. We read contracts for a living, statutes, cases. I see the term soundness, and I can probably guess what they may be asking me to answer. But when I'm making a legal disclosure to a third party about the condition of property, I don't want to guess what they're asking. I want to make sure I get it right. So how is soundness defined? Well, it's not defined anywhere. And how do we answer a question that we don't know the definition of the specific term they're using? How's habitability defined? I have a general understanding of what habitability means, but that doesn't mean I understand whether an inspection has findings that relate to habitability. Somebody else may decide that an inspection report does relate to habitability, when my interpretation is, no, the inspection report has to do with whether the locking mechanisms work. It doesn't mean you can't live in the unit. So that brings us to the next bullet point. How do we know if the findings relate to safety, soundness, structural integrity, or habitability of the project's buildings if there was no report that specifically makes that statement? It's open to interpretation. And before we even get into, do we have a duty to disclose this stuff? How do you answer yes or no to a question you don't know if you don't understand the terms? Which brings us to the next slide, which also is on the new question 2 of the addendum. It asks the association to provide a copy of the inspection report and board meeting minutes to document the findings and an action plan related to whatever the last inspection was deemed to be. Well, you could have an inspection report. Somebody could go out and do a termite report, could go out and look at the paint coating and make a recommendation to the board. That doesn't mean there's an action plan. Does peeling paint cover on a 30-year-old building affect the soundness, structural integrity, habitability, or whatever the other term was? I don't know. But to provide a copy of the inspection report in the board meeting minutes documenting an action plan, there may not be an action plan. But then do you give out inspection reports at all? There is homeowners associations, again, typically get inspection reports to allow board members to make informed decisions. It's not to provide to third parties to make their own subjective value judgments and rely on those reports. There's a significant impact in terms of how we ask reports to be written when we know they have to be provided to third parties, or if we know third parties are going to rely on them for other purposes. So providing minutes shouldn't really be a big deal. There are already legal obligations regarding the disclosure of board meeting minutes. What about executive session? A lot of these difficult decisions may be intertwined with whether there's pending or potential litigation. Those discussions typically are in executive session. Executive session minutes typically aren't given out because there are privacy and privilege considerations, which brings us to the impact on SB 800 claims, construction defect claims against the builders. Typically, the inspection reports and construction defect claims are written for the association in care of legal counsel to protect the association's attorney-client privilege and the attorney's work product in guiding the association to resolve a claim. Those reports shouldn't be given to anybody, let alone lenders who are making loan decisions based on them. Doing so could violate the attorney-client privilege and waive it. It could jeopardize the association's ability to have a successful recovery on their construction defect claim. So there are some big decisions to be made here, even if the board decides it wants to be as transparent as possible. So next question goes to Zerf.
So question number 3 of the addendum says, is the HOA or cooperative corporation aware of any deficiencies related to the safety, soundness, structural integrity, or habitability of the project building? That is a loaded question. So the questions that kind of arise from this are, how much does the association have to do to determine whether the association is quote unquote aware of the deficiencies, right? What does that mean? For a current board or for a management company receiving these addendums, how far back do you go? How much do you have to dig? What constitutes corporate knowledge, right? So the question is the HOA or the co-op aware of these deficiencies? What is corporate knowledge of that, right? Do you have to go back and review records? Does the association or the board, or rather the preparer of the addendum, have to go back to really figure out and piece together what it was the association at some point knew regarding safety, soundness, structural integrity, or habitability of any of the buildings of the project, right? Are we looking through records? What about interviewing people? For many of you who are participating today, you might just be on your board for a year, a couple of years. Some of you may be long haulers, but most people on the board are only on the board for a small period of time. And so when they leave the board, that knowledge typically goes with them. So does this question require on the part of associations, or again, the preparer of these responses, to interview people at some point who were a part of the corporate board and may have had knowledge about it, right? This can you can dig as far back or go as deep as you need to with a question like this, because these terms are not clearly defined. Next slide. Questions 4 and 5 here. Question 4, are there any outstanding violations of jurisdictional requirements, zoning ordinances, codes, etc., related to the safety, soundness, structural integrity, or habitability of the project's building? Well, how does the association know if no citation notice has been received? How does the association know if there are outstanding violations if for some reason they haven't received a copy of the violation, or perhaps it's been lost, or perhaps it was received by the prior management company, but not the current management company, right? The association isn't necessarily in a position to know whether or not there are these outstanding violations. Number 5 is perhaps the most preposterous of all the questions in this rather preposterous addendum, being, is it anticipated that the condominium or the co-op project will in the future have such violations? I mean, how does one even answer this? We don't have as much as lawyers are asked to kind of project in the future. This is something that even we can't project, right? So much less how are you as the preparer board member supposed to know whether you will have future violations of zoning ordinances or codes? So what is anticipated for a future violation? This is really just a ridiculous question amongst a bunch of ridiculous questions, but this is just a great example of how much of this is really unanswerable based off of the information that the association or the preparer has at the time. Next slide.
And on that future violations, the way this comes up hypothetically, worst case scenario, the association answers it, no, we don't anticipate any future violations of that type. 9 months later, you get a letter from the city saying it's been reported to us X, and you need to clear this up. And somehow somebody involved in a transaction that relied on the statement that you didn't anticipate it hears around that this has been going on for a couple of years and you should have figured it out. That's the problem. So trying to guess what may or may not happen in the future is kind of a fool's errand. So question 6, does the project have a funding plan for its deferred maintenance components or items to be repaired or replaced? Coupled with number 7, does the project have a schedule for the deferred maintenance components or items to be repaired or replaced? So I'm a lawyer and I hear the term deferred maintenance bandied about all the time. My question, what is deferred maintenance? The Fannie Mae Freddie Mac guidelines refer to something like severe deferred maintenance, but they don't define deferred maintenance. Severe deferred maintenance is something along the lines of there was a condition so bad you had to temporarily evacuate some portion of the development, in addition to a couple of other parts of the definition, but they never talk about, the questionnaire asks about deferred maintenance. Is scheduled maintenance or replacement in a reserve study deferred maintenance? Well, when I hear deferred, I assume that it's something that's put off that otherwise should be done. So to me, a reserve study doesn't deal with deferred maintenance. It deals with scheduled maintenance and repair and funding for it. But without an answer, somebody else could say, well, that just refers to your reserve study. Well, you can always provide a reserve study, but to answer the question with a term like that that's not defined exposes whomever's answering it to risk. Then you get into what if the reserve study is wrong? We're relying on it. Is it reasonable to rely on it? I think so, but you're interpreting somebody else's work to make disclosures that a lender is going to use to assess whether a loan is appropriate for this property. And it's really important that we understand the terms. Next question is deferred maintenance. If you have a roof that's scheduled to be replaced at 20 years, and at the 20-year mark, you go to a roofer who analyzes it and says, you know, we think you can get a few more years out of this roof. Well, that's now maintenance or repair that's scheduled, but is being deferred, but there's nothing wrong with it. The board's relying on an expert. So does that need to be disclosed? How do you assess that? Zuri, you were.
Yeah, exactly. I was just going to say, you know, the difficulty with reserve studies, for those of you who know, is that it really is just a projection of when components that the association is responsible for maintaining or replacing, when those components will be ready for replacement. But a lot of things happen that can alter whether or not that replacement actually has to take place in accordance with the timeline that's set forth in the reserve study. And so reserve studies are really, and this is one of the reasons why the statute requires that they be updated every 3 years fully, right? Because it's kind of, the circumstances change, and as a result of these questions, it becomes really difficult to determine whether or not an association just has to press forward with maintenance and replacement of components regardless of whether or not that's necessary, just so you don't have to answer yes to a question like this on the addendum. Next slide, please. So now that we've thrown all or some of the questions out to you, what are your options available to associations when in fact you receive these addendums now? So there are a few. We've broken them out as number one, an association does not have to respond, or you don't respond to the addendum at all. Option number two is an association can decide to provide responsive documents only in response to the questions. Option number three may be for the association to provide limited written responses, but not necessarily go all the way into the details and the investigation that we've talked about earlier. And then the fourth and last option available to an association would be to actually forward the Fannie Mae or Freddie Mac addendum to its legal counsel, to its general counsel, corporate counsel, for counsel to respond to in a manner that would be more appropriate and would be more detailed. The next slide. So we're going to kind of just talk through what these options would look like. The first option I mentioned is that the association actually decides not to participate in this addendum process, this escrow process at all, and not respond to the addendum. It's really important for board members to understand, as a legal matter, associations are not obligated to respond to lender questionnaires. As I mentioned earlier, questionnaires are routinely going to be provided to an association during a real estate transaction. And as I mentioned before, that's so that the lender can help assess the risk associated with lending on a particular property. But the fact that this happens, and this is information that the lender is requesting, does not trigger an obligation on the part of the association to actually participate and respond to these lender questionnaires at all. There is no requirement to do so. In fact, the association's disclosure obligations are extremely limited under law. There are civil code provision sections we've set forth here that basically provide that an association's disclosure obligations really are limited to the production and inspection of documents. And those documents are actually only available to members of the association, not third parties. So this whole process that associations or management companies on behalf of associations go through is really an attempt to help facilitate transactions and to help facilitate actions that your members may be taking regarding their property, whether it's refinance or a sale, something like that. But there are no obligations that the association has to engage in this kind of fact-finding mission with the lender or on the lender's behalf. There's also case law. John mentioned one of the cases before, Kovich, there's a Osanian case. And both those cases basically provided that and protected the right of the association to really limit what it is it has to disclose, not just to third parties, but even to members, right? Especially as it relates to litigation and some of the issues that frankly would come up during this addendum. So the association has limited disclosure obligations. And frankly, responding to these questionnaires and participating in this process comes with some pretty significant risks. Think about the risks of the threat of litigation from the involved parties in the actual transaction. If the association doesn't respond at all, you're going to get not just lenders, but you're probably going to get the homeowner contacting the board saying, if you guys don't respond to this, my sale is going to fall through. If you don't respond to this, I'm not going to be able to do my refi, right? And if you don't respond to this, I'm going to sue you. I'm going to sue the association for essentially for some sort of a breach action or for interference in a contract, right? So there's always going to be the threat of litigation, unfortunately, when the association engages in the process. If an association decides not to respond or participate in this, in the Fannie Mae Freddie Mac addendum process, then there could potentially also be the community perception that the association is not being helpful, or rather is actively trying to block transactions and sales in the development. And nobody likes that, right? So there's always the risk associated with not responding is maybe the community perception of how the association is kind of thwarting their own the members' actions. And then, of course, the biggest risk is that if the association decides not to respond, the real estate transaction could potentially fall through entirely. And we're going to talk about why that can come up during any of the options, frankly. But that is definitely a real risk, or certainly something you're going to hear from members if the association decides to go with what I consider to be the safest option by not responding to the questionnaire addendums. Next slide.
If I could add to this just a
Oh,
little
yeah.
bit before we go on, there are a couple questions in the Q&A about, why are we making this such a big deal? These are things the association ought to know. They ought to be willing to help. It should be transparent. In general terms, I don't disagree with those sentiments, but we're talking about the duty to disclose and disclosures made to facilitate real estate transactions. And as everybody knows that's ever bought or sold a home in California, there's a disclosure obligation from the seller to the buyer. The seller has an obligation to disclose any known physical conditions of the property that might materially affect the buyer's decision to buy. Homeowners associations don't have that obligation. They're not part of the transaction. And up until when this started to go into effect in about October, and really gained a head of steam on the first of the year, associations now are being asked to provide this information for the convenience of the lenders that have other options to gain the information if they're willing to do the work. So when somebody asks, well, why not just provide it if you know the answers? Because when the association doesn't have a duty to disclose, but chooses to do so anyway, it takes on liability related to the disclosures that it doesn't have if it doesn't make the disclosures. Once you voluntarily inject yourself into a disclosure process that others are relying on, with the best of intentions, you take on legal liability you can't avoid. And homeowners associations aren't set up and created with a pool of funds to respond to disclosure lawsuits. For voluntary disclosures, you don't have a legal obligation to make. That's why this matters. Zer talked at the beginning about there have been Fannie Mae and Freddie Mac questions for as long as those entities have been in existence related to accounting information, the status of reserves, how many delinquencies, how many units are owned by renters, all of those things that aren't disclosures about physical conditions. This is fundamentally different in terms of the risk you're taking on. So option 2, if we go to the next slide, provide documents only. This is a way to avoid providing substantive responses to questions that we've already explained. You may not really understand what they're asking, or they require value judgments to understand an answer that may not be shared with the other side. Document production alone is closer to the association's current disclosure obligations to members anyway, because the association already discloses at year end and at member request a number of documents to members. So this kind of rhymes with that and is more controllable. The risk, the lender may say, I don't just want your documents, I want yes or no answers that I can rely on. Well, that's a lender value judgment that isn't really the association's responsibility. Again, you could have the homeowner pressuring whomever is responding to the questionnaire to provide yes or no responses to support the documents and support the borrower's request. And again, you can have the same result. The transaction may not proceed if the lender says, we're not doing any more work on our end. If you won't tell us yes or no, we're walking away from this. And it could impact the community's ability to have as many funding sources. So next slide. Zer, this is yours.
Yes, it is. So option number 3 is an association board can decide to provide limited written responses to the addendum questions. This is actually the trickiest option because you're kind of threading a needle here. As we went over before, and I think as is apparent to anyone who's actually read the questions, these are relatively poorly drafted questions. And so as a result of that, there are multiple responses oftentimes that are applicable or could make sense based off of your interpretation of the terms that are being used in the question. Furthermore, some of the questions ask for a yes or no response. but very rarely is a yes or no response kind of a complete response. Unfortunately, the questionnaire doesn't really allow the preparer to explain the context for the yes or no answer. So if the question is the association aware of any deferred maintenance? And we use, for example, the hypothetical that John posed earlier. Does the association have any deferred maintenance? Maybe the answer is yes, but maybe that's because the association consulted with its roofing expert, and the roofer said, "Hey, you actually can get another 5 or 6 years out of this roof. You don't need to replace it immediately." So is that technically deferred maintenance? Yes. But can you explain what deferred, why the maintenance is being deferred? No, that's a problem with the form. Understand that one of the other problems with, or one of the other aspects of providing limited written responses is that some of the questions, as we went over before, still request production of documents that the association has no legal obligation to disclose to third parties, right? So providing just limited written responses is not enough for purposes of engaging in the addendum process. There are risks, of course, associated with taking this option as well. The most common one is that, frankly, lenders just aren't accepting limited responses. As much as Fannie and Freddie and all the lenders will say that these are, optional questionnaires, it is more common than not, I would say, that if you provide bare bones responses, the lenders are going to come back to you, meaning come back to the management company or to the board and say, "We need more information. This is not appropriate response," right? "You need to give us more background on this information." And so, although these are kind of indicated, or they're kind of marketed as being optional questionnaires, anyone who's actually had to live through this process and participate in the escrow process for a Fannie or Freddie loan will know that this is very much something that they require. It is not optional. And even in providing limited responses, they oftentimes are going to come back to you and say, "We still need more information." Of course, the risks in providing limited written responses. Again, the homeowners are going to pressure the preparer to provide further responses. Just give the lender what they want. Just answer those questions. Just turn over those documents. Or again, my real estate transaction is going to collapse in one way or another, right? And so if the association is in this situation, there are just always risks that that the owners are going to come back, the parties are going to come back and say that even the responses the association provided somehow impacted negatively the transaction itself. And then, of course, anytime the association provides written responses, it could be sued if there was improper information provided or an inadequate disclosure. Again, not because the association is intentionally trying to mislead anyone during this process, but because information changes, facts change. The board might not even be aware of some of the circumstances that subsequently come out and end up, as we said before, exposing the association to liability. Next slide.
There's one other aspect of providing a written response. If in a purchase sale transaction coming through a lender asking for this information, it's not just the risk that the lender and maybe the buyer are going to rely on these statements. What happens if the association voluntarily answers the questions? The lender turns down the loan, the buyer says, "I'm not buying," and now your member, the seller, comes to you and asks, "Why did you guys make disclosures about the condition of the buildings and blow up my sale? I didn't ask you to do that." So there are risks on all sides with this. It's not simply well, we don't want to cooperate because it could cause trouble. There are so many aspects of legal risk in this that really understanding the full picture is beyond what does the lender want. So option number 4, forward the addendum to legal counsel for response. In presenting this option, we're not necessarily asking that everybody do this, but it is a way to manage the responses because legal counsel is going to understand maybe how to use disclaimers, limit the liability and protect the board and management company, try to massage answers to the extent it can be done, but also to encourage the lenders to do their own inspection, to do their own independent analysis, and not rely on the association's limited understanding or inability to understand the questions. It requires cooperation, communication, and production of documents to counsel so that accurate responses can be provided. Zur went into a number of questions previously. Do we have to interview people? How far back do the records need to go? What happens if you get a new board every year and we need to go back 5 years for information? And some of those people may not be around. All of that could go to corporate knowledge of these conditions. What about records that maybe didn't get fully transferred when the association changed management companies if you're not self-managed? There are so many pitfalls in all of this where maybe we don't get all the records, but a board member 4 years ago remembers something. So, corporate knowledge is tricky and legal counsel might be able to navigate that. The cost shouldn't be borne by the association. They ought to be passed through to the homeowner involved in the transaction. You can have an attorney spending several hours trying to get this right. That shouldn't be at the association's expense. It's not an association obligation. But if you do get authorization from a homeowner to proceed with responding to the questions and the homeowner agrees in advance to protect the association and incur the association's expenses and reimburse them, maybe this is a better option. The risks of it will take more time. It will significantly increase costs. That's the cost of doing business for the association to protect the board members and management if there is management. But again, you need the cooperation of the homeowner that's going to benefit from this before you proceed down this path or any other path that involves a substantive response, or the association and management can really get hung out to dry, not only cost-wise, but legal liability. So we're getting down to the end of time, and we've got some an analysis of risks and benefits, and then some recommendations for you. So if we go to the next slide.
Sure. So just to wrap up here, there are risks associated with responding. There are risks associated with not responding. Here's the slide on what are the risks in overview for responding. There could be potentially, as John has mentioned, liability for providing inaccurate responses. Whoever is preparing the addendum questionnaire responses is essentially bearing that liability, whether it's the management company, the association, the board members themselves, or legal counsel. Of the three, legal counsel is typically in the best place to bear that risk, but understand there's liability anytime anyone prepares responses to these questionnaires. As John mentioned earlier, one of the risks in responding is that you're creating a duty where frankly there is no legal duty that currently exists, right? It doesn't exist. And so by participating in this process and providing responses to really these probing, very difficult to answer questions, you are creating a duty that didn't exist beforehand. It also creates an obligation to investigate before you provide those responses, right? Because you're providing responses upon which lenders are making a decision about whether or not to lend on a property. If in fact you provide just willy-nilly answers and you're not paying attention, or you're just filling it out however you want, that's not appropriate. That's not performing due diligence. So you have an obligation to investigate any responses that you provide. It increases the risk of litigation if the transaction collapses, as we've talked about before. You understand that in responding, it also increases the risk of litigation if the buyer or the lender somehow believes that the disclosure was incomplete. And then there are insurance coverage issues associated with responding and making disclosures about structural habitability, soundness, all the components that are kind of addressed in the majority of the questions could have potential insurance ramifications.
If I could, on that one point, the reason there are insurance ramifications, if the association or manager or whomever fills out a questionnaire is alleged to have not made a complete disclosure, that would often be characterized as an intentional or negligent misrepresentation. Sometimes we refer to it colloquially as fraud. Fraud claims, the way we all understand it, lying to somebody, not being upfront and complete when people are relying on it, insurance typically doesn't cover that. So the cost of being helpful here to help out somebody trying to get a loan is perhaps an uninsurable risk where you're alleged to have lied or been incomplete or been reckless. The insurance issue is a big deal.
Yeah. And the next slide, there are risks associated with not responding, as you mentioned before, right? Option number one is not providing a response. It's possible the transaction may collapse. You may have member anger, a negative perception in the community that the association is not assisting members during these processes. The project might be deemed as unavailable or not qualified for future Fannie and Freddie financing. And of course, there could be potential negative impact on property value. I think we are right about out of time. So last slide.
Final slide. How can we reduce risk while trying to answer? It's a loaded question, a loaded topic. But lawyers try and figure this out all the time. That's what we get paid to do. The use of disclaimers. I write letters all the time trying to disclaim responsibility for somebody relying on what I'm telling them when I'm trying to provide information that I believe to be true, but can't be all knowing. The problem with disclaimers when you know somebody's relying on what you tell them is if they claim that fraud and misrepresentation can't be disclaimed when you know somebody's relying, which is why when you don't have a duty to disclose, but you do so anyway, you're taking on risk that may be uninsurable and you can't get away from if somebody claims you weren't full and complete. And the issue here isn't just whether you're going to be liable, it's whether you have to pay to defend yourself. That can be as expensive as a potential liability that maybe isn't as great. There's an option to disclose only to the current member and let the current member decide what they're going to do with the information. To the extent you're going to provide answers, this is probably the safest option of all. Have legal counsel handle the request. We just talked about the burdens and risks and benefits of that. Seek indemnification from the member. If a member is trying to get a loan or the member has somebody trying to get a loan, you can have a member say, I'm going to pay the association's legal fees to answer this stuff, and I'm going to defend and indemnify the association if there's a lawsuit. The problem with indemnity goes back to the same thing as a disclaimer. You can't get indemnification for fraud. So if there is a fraud allegation against the association for answers that are deemed by whomever relied on it to have been improper or fraudulent, you can't go back to the member that said, please answer this on my behalf and say you have to indemnify. You can't indemnify against fraud. Encourage the lender to inspect documents. Encourage the lender to do its own independent assessment generally. We always recommend. And finally, for boards. Boards need to discuss the pros and cons with legal counsel about how to approach these things before deciding how the association is going to proceed across the board. You don't want to make different decisions in different circumstances, or because you got to treat your members in the same fashion and treat them all fairly. And then finally, once the board makes a decision about how the association is going to proceed, the board needs to notify the membership of the issues that we've been talking about here, how it's changed, why the association has legal risk, and why the board made a decision that it did in terms of how the association is going to respond going forward, so that there are no surprises when this comes up later.
Okay.
So I think we're about out of time, but we've got time for questions, Dave.
Okay, so we have 15 minutes or so for Q&A. Thank you both for the wonderful presentation. I also want to thank Marta and Krista for their presentation. They will be speaking to some of the questions. And I think we didn't have that many about the Coastal Commission, but we can go ahead and take some of those. And what I'd like you all to do is to take some time and do the upvote, the thumbs up vote, and so we can pick the most important questions, the ones that are most important to you. And so go ahead and start doing that. I would like to also thank our sponsors for the Q&A session. Again, Kevin Boland Insurance Agency, the CID Consortium LLC, Hughes Gill Cochran Tonetti, PC, and Monster Tree Services. Thank you very much for sponsoring this session. We'll take a couple more minutes to get to your votes. If you put questions in the chat feature, you may want to move them over to the Q&A because we're really watching the Q&A, not the chat. And let's see here. Okay, so we can start looking at the most frequently asked questions. And the anonymous attendee, I think the FM, let's see, that just went. Freddie Mac, Fannie Mae questions make sense. You are making these questions more complicated than they are. As a homeowner, I want to know the answers as well. The board of directors should know the answers to these questions. This is another example of why lay people should not be on the board of directors. I think that's a comment, not a question. But I think imputed in the comment is that, I mean, really how important is it for the board to make these decisions, and should homeowners know them well?
I'm sorry, Dave, the question is how important is
it for the board of directors to understand how to respond to these questions? They're saying you're being a little more complicated than you need be here.
I don't think it's being overly complicated to advise board members that when they don't have a duty to make disclosures about the condition of property to third parties, but they go ahead and do so anyway, they have risk that's difficult to quantify and may not be insurable. I mean, it's, real estate disclosure law in California has been in effect, I'm guessing, about 40 years in terms of the duty of a homeowners association versus the duty of a seller. And again, it's sometimes people think of this in terms of a good Samaritan law. When you don't have an obligation to act, but you voluntarily do so, you now take on all the obligations for whether your action was reasonable, and you put yourself in a situation you can't walk away from when somebody decides you did it wrong. So, and in terms of, well, everybody ought to know this. Well, I've got a number of questions about what they're even asking. And it's really easy to say, well, a lawyer can create a question out of any term. When you're talking about disclosure liability, you bloody well want to know that you're answering something in a safe fashion, and that what you understand the question to mean is what the question actually means. So, these aren't social gathering decisions. You're risking the association's financial viability by wading into an area that you don't have an obligation to wade into because somebody thinks it'd be helpful for them.
Right. Another thing to, on that point is that, boards do want to participate and do with their members, and it's only reasonable that boards want to help members out during these circumstances. But understand that wanting to help out a member who's trying to sell his or her unit, or wanting to help out a member who's going through the refinance process is a lot different than actually having to do so. This is not a part of the board's obligation. Corporate boards for common interest developments in California have a lot of obligations. You're probably not even aware of all the things that you're required to do as a board member in California. So it becomes it's more important for boards to understand that you need to focus on what it is you are obligated to do, as opposed to simply what you can do to help out a member, right? And if you make a decision as a board to go ahead and to extend yourself to do so, you do have to be aware of the risk that you're carrying. Now, there are clients that are willing to do so. They say there is no way that we're not going to participate in this. We're going to do our best to respond to these questionnaires, these addendums, because we want transactions to occur, and we want refinances to occur. We want all of this to happen, and that's perfectly fine. The goal for us as legal counsel, and for your own legal counsel, should be to make sure that you as a board understand what that risk is and make a conscientious decision to accept it if that is what you want to do. You just never want to be in a situation where the board is accepting this risk, not understanding that it even exists, right? Or what the expanded risk is now in engaging in this process. So it's really just a matter of making sure that boards understand kind of the whole universe of issues that are being raised by these new addendums, and thinking through what this process would look like and coming to a decision. That's really the most important part of this whole presentation, is making sure you understand there are options and you agree to accept the risks associated with the option that you select as a board.
Yeah, that's the board's fiduciary duty, to act in the best interests of the association.
Yep.
Well, what I'm hearing is that it's important to have, especially as a volunteer board, to have expert opinion to protect your position so that you can protect your risk. If you so choose not to accept the expert opinion, then you are in turn accepting the risk at the board level. So that's something that you need to weigh very carefully. And it's nice to be the nice guy, but unfortunately the law and the ambiguity is a bit of a problem here. How do these disclosures impact the content of the annual budget disclosure document, if at all?
I don't think they do.
Yeah.
So the annual budget report, the annual policy statement that goes out with the budget every year, that's an association obligation to the members. And Zur talked about what the association's disclosure obligations are generally, and she gave a few code sections. The documents that you'll find in those code sections, I think largely, if not entirely, are all part of what goes out in the annual budget report. This doesn't affect that at all. And any member can get a copy of the annual budget report and all of those documents and provide them to a lender themselves or to a potential buyer. And they're often asked for in that context. This is much different. These are qualitative assessments about physical condition of property. There's never been an obligation to go there.
Would this have any impact on the reserve studies? If you do the qualitative research?
I don't think so. It may have when reports start getting shared for reliance by third parties, it could have an impact on how inspection reports are written, the terms under which a vendor is going to agree to evaluate something and write a report, and what its use is for and what it shouldn't be used for. Would that translate to reserve study preparers? Maybe in some contexts, I don't know. But it doesn't impact what goes into a reserve study.
Right. I think what it might impact, as we talked about, is whether or not in responding to these questions, if a board decides to respond to them, whether or not the association is then going to be more inclined to proceed with some of the replacement or the obligations that are set forth in some of the repair projects that are set forth in the reserve study, right? Because as we mentioned before, when we're talking about that deferred maintenance, the simple kind of interpretation of that is, are you doing everything according to schedule? Well, most associations, frankly, don't do a lot of these reserve projects according to schedule for a number of reasons. Either there's not enough money in the reserves, or because they've been, they feel like the roads are in fine condition. They can wait a couple more years. But if you're inclined to answer these questions, it might impact really whether or not the association is going to keep on top of that schedule more closely, so that it doesn't have to answer, yes, we have deferred maintenance on these addendums.
Okay, well, here's one. Speaking of deferred
Dave,
maintenance,
before you go, there's
Yeah.
one more way of thinking about this that I think everyone should take to heart. If we were talking about legislation from the California Senate and Assembly and the governor that put this type of burden on homeowners associations, it would probably be a 2-year bill. First off, there would be an outcry from the HOA industry, the management industry, about all of the risks and burdens that are being taken on that we've been talking about here. And the legislators would need to take into account the impact of these legal obligations and the associated risks and costs on whether it was good legislation. We'd see where the chips fall, but there would be a lot of input from all of the stakeholders on whether this is appropriate. What we have here is Fannie Mae and Freddie Mac, after the Florida Surfside disaster, saying, we don't want to get stuck either owning or insuring a bunch of loans that just became worthless because of this tragedy. So now we're going to want this more information. They transfer the risk to the lenders to get it. So what we have here isn't legislation for the common good. This is the stakeholders that stand to profit from it. And I'm not knocking that. That's an important part of the process. They're now kicking the can over to the homeowners association to take on the risk and spoon feed them what they need to be able to get Fannie and Freddie financing and make more money. So this isn't about whether legislation makes sense or not. This is being imposed by the parties making money off of it. And it's not the association's burden to take on that risk, which is why these issues are so important to evaluate also.
So this is important, I think, in terms of what you're saying is this policy or regulation. It's not necessarily a statutory requirement. It ties in well with what the California Coastal Commission is doing in terms of their policies that are being promulgated through their authorities. These are private enterprises, that makes sense. So they will and they do have impact on HOAs and on individual homeowners in those HOAs.
Yeah.
Let's take a look. Julie asked a question. Can there be a distinction between deferred replacement versus deferred maintenance? For example, we do maintenance continually on every key system, but we do defer the modernization and replacement on many systems as it's not crucial or critical from both a cost benefit nor a wear and tear perspective to replace at this time. I think that's a question for you, John and Zur.
Well, I mean, I think that we can make a distinction between those two things. The problem is that the addendum does not make that distinction, right? And the addendum, frankly, doesn't even let you explain yourself if you want to try to make that distinction. So I think that's a fair. I think that's a fair question. I think that would be a reasonable approach in terms of providing a clear and kind of comprehensive explanation to the lender about whether, when you're responding to this, what you actually mean by this. So I think that's a fair distinction to make. Unfortunately, that's just not what's set forth in the addendum. And so it goes back to this issue of how does the association properly respond and give the lenders what they want on these questions so that it doesn't impact the outcome of these sales, right? It's just a hard one to respond to because they don't really parse those issues out the way that, frankly, they should be in order to provide an appropriate response.
Yeah, there's no definition.
Yeah.
Yeah. Well, here's a question about SB 326 and the implications, heavy implications with respect to SB 326 and CC 5551, which is, I believe, the apartments, inspections and actions. What if you haven't already answered this, I think you have maybe, what is the obligation to disclose findings and status? That is, it says our obligations. I presume that's the homeowner board's obligations to disclose any of the findings that they have.
So the legislation behind SB 326, Civil Code 5551, didn't include an obligation to make those reports available to everyone. The association has an obligation to inspect and to repair and generally to ensure that they're all in good condition, safe working order, and that nobody's at risk, and to take steps if those aren't the case. As a practical matter, I think the board could make a decision that if you do get an SB 326 inspection report that A says these are in good condition, or B says you need to make these repairs, and then the repairs are made, and then you get a clean bill of health in a final report. The fact that you don't have to give those out to your members necessarily doesn't mean maybe that you wouldn't want to. And that's a decision that the board can evaluate and decide whether it's going to make those available to members. Whether you make those available to third parties that aren't members that don't have a stake in the community is an entirely different analysis, because you've got no obligation to give third parties anything like that. So it wouldn't surprise me if there's new legislation to address whether the members get that stuff beyond what the legislation currently has. And it wouldn't surprise me if boards were to evaluate that and say, when we fulfilled our duty and done everything right and gotten a clean bill of health, we want the entire membership to know that. and have documentation of it, because it's a good thing for everybody to know, to show that we've done our jobs and we've been told things are in good working condition. I think boards can do that, and those things are going to be asked for, but there isn't, that's not currently required by law.
And can someone ask, a homeowner ask to see that report? If the board decides to go ahead and file the report, can the homeowner ask can a different homeowner request to see that as a disclosure of documents?
Well, so you're talking about an inspection of a single balcony that is somebody else's unit, generally speaking?
No, I'm talking about the Fannie Mae, Freddie Mac documents.
Well, it's not within the records that are available to members under, what is it, 5200? Civil Code
Right.
5200.
So as John mentioned earlier, right, or perhaps I mentioned earlier, so there are documents that the association is required under law to provide for review and inspection to members. But the documents that are requested in the addendum do not fall within any of those categories. And there are a number of categories. So not only is the association, again, disclosing documents that it doesn't normally disclose, it's turning them over to a party that it wouldn't even have an obligation under law to turn it over to, right? We're turning these documents over to a lender, not even to a member.
Okay.
So arguably no.
Yeah, so that would be that's an answer to the next question there. I'm gonna give a quick one over to Marta and to Krista. Another question they had, and this is flipping over to the coastal issues, creeks and drainages that depend upon current sea level for alpha. I wonder how those would be able to function over the long time if some of these policies were to come into effect. Have you come across that?
So that is something that we're looking at, and we're working with a group called Milliman, and they are insurance actuarials. And they too are looking at drainages and waterways and how they might affect the ocean and stopping of it. If you consider the Montecito mud flow, all of that mud was stopped on its way to the ocean, where normally it would go to the ocean and then become sand further down south of the beach. So putting reefs out in the ocean, it doesn't, what we're hearing is that those groins and reefs that are out in the water don't affect the waterways disgorging into the ocean and sea level rise directly. So it's more of a dam issue and redoing the dam, or when they take the dam, the sediment that's built up in the dams, they can truck it down to the ocean. The bigger problem with the sand replenishment on the California coastline is that they use the East Coast sizing of grains and granules for the sand, and they are much, much finer than the California side. The California size grain of sand is much larger, and so it's harder to find sand that's appropriate according to the federal standards for the West Coast than the East Coast. So a lot of times the sediment can be brought down, but it's not as easy, and that's something we're looking at the federal level. I'm not sure that completely answered the question, but it is something that is being considered at this time.
Well, it's I think a very good answer, and I'm going to bring this to the concluding remarks. I want to say thanks to Marta and Krista. We will be talking more about these issues in a few weeks, I guess, at their the Smart Coast annual policy summit in Long Beach. It's going to be a heck of a good time, and we'll learn a lot about the science and disclosures there. Remember, there is an ECHO discount if you want to sign up and go to that. We highly recommend that. I would like to thank everyone for participating today, especially our presenters, and thank you to John and Zur for coming today and doing a great job and asking, creating lots of questions in an area that's obviously very, very squishy at best, and it's difficult when you get regulatory agencies or organizations like Fannie Mae, Freddie Mac coming down with their own requests and trying to comply with this. I would also like to say thank you to everyone here for being a member of ECHO. But if you're not a member of ECHO, we would love to have you consider joining. This year ECHO has planned more than 60 online events, In addition, we offer vast arrays of resources for HOA boards and homeowners, including personalized guidance on challenging issues and a series of educational programs. You can join ECHO by going to our website at www.echo-ca.org and clicking on our membership tab. For those of you interested in meeting in person, we will restart our resource panels very soon. I believe at the end of May. May 12th is the first one, actually. Also, we are very excited to announce the formation of the HOA Board Members Club, an exclusive group of HOA board members or former HOA board members who meet to discuss various topics that they select. This group is led by your peers, former volunteer HOA board members Miguel Sanchez and Tom Connolly. They are wonderful, experienced leaders. Please click on the sign-up sheet in the packet or email Patty Curzette to become a member of this exclusive and interactive club. If you are having issues with rising insurance premiums or maybe unable to find insurance because you're in a wildfire corridor or other hazardous area, please look for the ECHO Insight and respond to the insurance survey. Only 4 questions to answer. If there is enough interest, if we see enough interest in ECHO looking into developing a group insurance program for its members to help address some of these issues. Look for the April issue of ECHO Insight to respond to the survey. This concludes our planned program for today. I want to thank Krista, John, Zur, and Marta for your very informative presentations. Once again, thank you to our sponsors who made this broadcast possible for anyone who wants to see it. And of course, thank you to all of you, the attendees, for participating in today's webinar. ECHO appreciates your investment in education to build better HOA communities.